Good afternoon, everyone. Thanks for joining, and hopefully you're safe and sound in your offices and you're not driving in the storm that's facing its head. And you can probably see it in the background here. It's getting cloudy. So it's about 1:31 now. I'm going to just jump right in. I know some people may be joining shortly. I appreciate you coming out, and I especially appreciate Irma's giving me the opportunity to speak with you today. I have an hour to talk with you, and we've got a lot of material to cover, so I'm going to jump right in. If you don't mind, I'm going to just ask you to bear with me for a second. I can give you a quick commercial here of my background, and it also is in the handout materials at the end. Irma and Jen, they're going to post the handout, this PowerPoint presentation that I'm giving to you on their website, so it'll be available to everyone who needs it. Or you can email me and I'll make sure that you get a copy of it right away, okay? Many of you on this, I saw the list, we've got over 100 attendees, this is wonderful. Many of you are clients of the firm and you know us. For those of you who don't, I work with Irma for many, many years now in their early intervention program. I see Jen's here. I don't know if Jen has anything she wants to add, but and I am an attorney with Lehner Muchin in Chicago here. Our firm has about 45, 46 attorneys, and this is all we do is employment and labor matters. So we represent employers only on employment and labor matters, everything from soup to nuts. My focus of my practice for the past 30 plus years is devoted to primarily working with employers in the public sector. I would say 75% of my work is public sector, dealing a lot with, day-to-day counseling issues, dealing with matters in the administrative agencies, and also at the bargaining table. So again, welcome. I'm going to jump in here. You can see the topic we're covering is practical and legal updates affecting employment and labor laws in Illinois. It's going to cover a lot of the new laws and statutes that apply based on some activity that occurred late in 2021 and effective in 2022. And then I'm going to open it up and we'll spend the last 10, 15 minutes on some of the issues that are on your minds. You can ask questions through this webinar site, and I'll make sure that we can get them answered. If there's something on your mind, please feel free to ask along the way. So I'm going to jump in first of all and start with some very basics here. Okay, some very basics here. There's a new poster for 2022. So if you don't have that up, you'll want to get it. It was just published in January. So if you haven't updated your posters lately, you'll want to. I think the only substantive change you'll see is you can see that it references the changes in the minimum wage and, those kind of things that'll be on your mind. There also is a change in the law I'm going to be talking about with the Violent Crimes Victims Leave Act, a hotline number available for that. Wage Payment Act is something that's hot this year, in particular, based on amendments. We're going to cover that. You can also see there's a hotline there. So if you don't have it, you'll want to get that. And you can see right here at the website for the Department of Labor, you can get this for free. It is posted in both English and in Spanish. I'm going to mention this now because I wanted you to know it is one of the pending bills that there was thought about. In Illinois, do we need to post things in languages other than English? And as of now, the answer is no, with some exceptions, the FMLA law and some of the others. But there is a proposal so that all of these posters, these legally required posters, would need to be published in languages other than English. So be on the lookout for that. As of right now, if you put this up, that's sufficient. Of course, even better if you put it in Spanish if you have a large number of employees who speak Spanish as a primary language. The first change in the law I'm going to talk about is the Employee Sick Leave Act. Most of you already know this, that back in 2017, the law was amended so that employees can use 1/2 of their annual allotment of sick time for family members. And there's a list of covered family members that is spelled out. So for example, if I have 10 days that I get per year, the employer is required to let them use at least 5 of those days due to an illness or an accident or a doctor's appointment or a dentist appointment of a child, a spouse, a parent, a significant other, but not significant other, a domestic partner rather, grandparents. And so if you haven't addressed that, you'll want to make sure that your handbooks are revised to make it clear that at least half of the annual allotment can be used for family members. That is something, in my experience, most of my clients, they've just gone ahead and said, you can use all of it for either the employees or the family members. I think the logic is, as soon as you burn it, it's gone. So why not burn it early instead of waiting until everyone tries to hold on to it and then burns it at the end of the year when everybody's taking it at the same time. Excuse me. The 2021 amendment, which was effective immediately, last year, I believe it was April. And that is that now employees can use this sick time for personal care reasons, not only an illness or a doctor's appointment, but it could be even to stay home with the covered family members to help with their basic needs. So let's say that there's somebody who is in need of transportation to get to a doctor's appointment, or if they need help even making their meals, or, let's say their caretaker is off on vacation for a week or whatever it is. The employees are entitled to take some of their sick time, again, half of the annual allotment for that purpose. So this is just an expansion. This time off is paid because it's using their paid sick allowance. So you can run it concurrently with FMLA, provided that the reason is, that the time off is covered. Certainly the employee would have to be eligible for FMLA in the first place, being with you over a year and at least 1,250 hours. But they also have to have sick time left. And if they're taking it for a reason that qualifies for FMLA, we would have it run at the same time. Okay. All right. The next issue is a change in the Human Rights Act. I'm not sure it affects many of you, but I want to mention it to you. And that is that now there's a new legally protected category in Illinois, and it would be unlawful to discriminate against someone based on their work authorization status. I think we know that the proper standard is whether somebody is eligible for employment in the United States, and that would be the inquiry on your application, and that would be the inquiry during the employment process. Are you eligible for employment in the US? So if somebody has a green card or a visa that, even if it's temporary, let's say they're on a student visa and the visa is expiring in a couple months, we would not be able to hold that against them. We can ask for verification that they're presently eligible to work here, but for all we know, they've applied for an extension. I don't think this is going to happen a lot with you, but I wanted to mention it. I know there's a number of communities that I represent that are looking at whether or not they want to make an exception to the requirement in Illinois about police officers having to be US citizens. So certainly there are some jobs where you do have to be a US citizen, and that would be an exception, and that's not a change here. Another change to the Human Rights Act, and that has to do with the definition. Yes.
We do have a question. It says, our CBA conflicts with the sick leave usage law. Which would rule the day?
Oh, thanks for raising that. So the CBA would trump that. You can negotiate a term that is different from what the state says. There's a provision in the State Labor Act that says that CBAs, the parties can negotiate, and that would trump it. Now, that's the general rule, and it certainly is the rule here with sick days, and I'll tell you it on some of the other laws. And it is common for, parties to negotiate changes in that. Okay, I'll go to the next one. The next one here is, and thanks, Jen, please help me out if there's a question, because for some reason they're not showing up on mine, but that's great that you're able to help out like that. The new change of Department of Human Rights was that the definition of disability. So right now, an individual is protected under the State Discrimination Act if they personally are disabled, if they have a history of a disability. So let's say I had cancer in my history and I'm fully recovered, it's in remission, I don't have any symptoms, I'm still covered by the disability laws if I have a history of a disability. And another way to be covered under the disability laws in Illinois would be if there was a perception that I was disabled. I think one of the cases I had when the perception was first added was an employee who lost a lot of weight, and this employee was losing weight, was very his hair was falling out. There were other symptoms, and people thought that the person was sick. Turned out he was intentionally losing weight, and it wasn't associated with any disability, but he alleged that the employer believed or perceived him to be disabled. So he's covered even though he doesn't have a disability. Now this next provision expansion of the definition of disability would be if someone is associated with a person with a disability. I think where that comes in would be if I'm in an interview process and I'm interviewing Jen and she tells me that she has a child with a disability at home, it would be unlawful disability discrimination for me to say to Jen, hey, I don't think you're qualified for this job because you have a disabled child or family member at home, or spouse or domestic partner, because I can't hold that against you because you're associated with somebody with a disability. Again, I don't think you're going to have to worry about that a lot, but I do want to suggest that you add that to your harassment policies. If you have it already, say that you won't discriminate against actual disability or perceived disability. You might also want to add as a protected category someone who's, if you're associated with somebody with a disability, okay? And then anybody that's involved in the hiring process, you'll want to make sure that that's reviewed with them as well. Because sometimes people do volunteer. They might say the reason for the gap in my resume is because I stayed home, I have a disabled child, or I take care of my mother or something like that. So they would disclose that information. You want to make sure you don't rely on it. VESA has been alive and well for a long time in Illinois. This VESA law was expanded last year to cover individuals who are victims of violent crimes. So it doesn't only have to be domestic violence, it can now be sexual violence, gender violence. It could be other violent crimes. And remember, an employee can take time off due to their own need to get either medical attention or legal assistance, or maybe they're going into court to get an order of protection. Employees can take up to 12 weeks of unpaid time off for seeking medical attention, legal assistance, counseling, safety planning, other assistance. And that also would include if I'm talking to my lawyer about trying to get some help in court. That's up to 12 weeks of unpaid time off in a 12-month period. And like FMLA, you could define calendar year, rolling 12-month, whatever it is. This would be available to employees who are victims of violent crimes, if that's the employee themselves or someone in their household. And I'm pointing to household here because it's an expanded definition. It doesn't necessarily only mean family members. It could be a family member, but it could be a roommate who is in my household, and I'm entitled to time off to be with that person. This is unpaid time off. And there are situations where, let's say that somebody was a victim of violence and there was a need for medical attention. It's entirely possible that the time for VESA leave would run concurrently with FMLA. So that I'm taking VESA leave and I'm taking FMLA at the same time, and I'm using my sick time that's allotted to me by virtue of a union contract or a sick pay policy. So it could be that I'm on all three of those leaves at the same time. And that's what I mean by running concurrently. Now, of course, it has to actually be a covered reason. If it's that I'm seeking legal advice, you wouldn't run that with FMLA, even though I'm seeking legal advice related to a situation involving somebody who's a victim of a crime. If it's FMLA, it would be for a medical reason associated with a violent crime, or the recovery of an employee or a covered family member. Okay, I see a chat. There's another word that comes up. Does VESA have the same qualification standards as FMLA, 12 months and 1,250 hours? And the answer is no. Individuals are eligible for VESA right out of the box when they're first hired. So unlike FMLA, and I'm glad that that person raised that question, because we know there's a 1-year waiting period for FMLA. So it might be that somebody doesn't qualify for FMLA until they reach their 1-year anniversary, but they need time off for a medical condition related to domestic violence or violent crime purposes, even as a new employee. And that would cover part-time employees as well. Okay. I'm going to the next slide here. The Human Rights Reporting Act. This is something that everybody loves and looks forward to every year. Since 2020, we are required, all employers, including public employers, are required to do an annual reporting to the Department of Human Rights by July 1st of each year if they experience a non-appealable adverse judgment or administrative ruling. There's a form on the website. I'm pointing to it here. You just go to the Department of Human Rights website. It's a form that would be completed, and you literally insert the number of adverse judgments or administrative rulings. It's important that I'm pointing out this non-appealable. So for example, if I get an arbitration award, which would be covered here, it's an adverse judgment. If I get an arbitration award that says that, oh, my town did engage in, there was a supervisor engaged in sexual harassment of a bargaining unit employee. During the period when I can appeal that, it's not an adverse judgment, so I wouldn't need to report it. If I have a decision or an adverse action, adverse award from an arbitrator or an administrative agency, and I'm still in the appeal process, I still have time to exercise my rights to appeal, and I settle, then settlements do not need to be reported. This is only an adverse judgment or administrative ruling that is not appealable any longer. So at the point when the appeal process expires, it would be formal and I would need to report it. Again, the form is pretty self-explanatory and defines what's covered and what's not. It's broken down by what's harassment, what's discrimination, how much is it sexual harassment, how much is race harassment. Even though you don't have to report settlements, the Department of Human Rights does have the right to follow up based on the information you report, particularly if they find that you didn't report something and they find a violation. They have a right to follow up and ask you about settlements. I have not seen them exercise their right in that regard, and I think everybody knows these Illinois administrative agencies have enough on their plates these days, like all of us. So I haven't seen anybody been asked about settlements, but I do want to just have that, on your radar, because if, let's face it, we all think that every case can be won and every case can be lost, and you never know. And sometimes arbitration is a crapshoot, and sometimes we disagree with an administrative agency, no matter how good we think our case is. And if you're in the appeal process where you have a right to appeal an adverse judgment, you may want to take advantage of the right to settle that, and then you don't have to disclose it. That's not to say the information in the settlement wouldn't be disclosed through FOIA or something else. I'm merely pointing it out to you here because it would be something that you wouldn't have to report to the Department of Human Rights. Again, I haven't personally seen in my practice, I haven't seen the Human Rights Act, this part really enforced or used by investigators, but I definitely expect that investigators will look at this and say, last year you had 3 other claims of race discrimination, and therefore there's a pattern. And I think that they will certainly use that against you if given the chance to have access to that information. So I wanted to mention that opportunity to settle if you feel it's available. This is a reminder. This has been around for a couple of years now, but I did want to point it out because I'm still surprised at how many of my clients call me and forget this. The salary history ban, it did come as an amendment to the Illinois Equal Pay Act provisions. Employers are free to ask candidates their expectations about salary, their expectations about benefits and time off and things like that. The only thing I cannot do is ask, at your last employer, what were you paid? Did they reimburse you for cell phone? Did you have to pay any share of your insurance? Did you get a commission along with your base pay? Did you get bonuses? I can't ask about the history. And the logic in this law, and again, it's the expansion of the Equal Pay Act, the logic is that it might be that the prior employer had discriminated. And so if I ask you that information and I hold it against you, I'm perpetuating that act of discrimination by a prior employer. Two things to note as public employers, and I mentioned this already, it covers both salary and benefits. So if I were to say, how much vacation time did you have in your last employment, that would also be an unlawful inquiry. Two things to note for public employers, which I assume everybody on the phone is, information about salary history that's available through public information or through FOIA. That's an exception because I can talk to you about information that I can get freely through the public. So if you're talking about somebody that's going from one community to yours, they're coming from the town next door, then you can have this information and you won't be accused of using it improperly. Because I could have access to that anyway, particularly if somebody's covered by a union contract or it's something that I could get through FOIA. And then secondly, if it's an intra-agency transfer. So if somebody's going from the police department to public works, that also is not confidential information. I can just simply pick up the phone and ask another department head. So that would be an exemption to that as well. I don't want to scare you with that, but that's out there. Okay. All right, my next slide here. The Freedom to Work Act. In my experience, a lot of public employers don't have no compete or restrictive covenant agreements, but nonetheless, this is a new law that's effective Jan 1 of 2022, and it certainly has restrictions on the salary levels. I won't bore you with that because that typically applies to private sector employees. I don't see a lot of no competes or no solicitation or confidentiality restrictions. Number one, most people wouldn't sign it, but number two, most of the information that people would have access to would be confidential. But there are certain people, not confidential, rather, it's disclosed in public information pursuant to FOIA. But there are certain jobs in HR or maybe certain finance jobs or somebody who has access to confidential information about union proposals, or internal investigations that might be asked to sign certain confidentiality agreements. There is a narrow exception that's still allowed in Illinois for employees to sign confidentiality agreements if they're in key positions where they have access to information. Starting Jan 1, I cannot ask you to sign one of those agreements if you are covered by a collective bargaining agreement, okay? The second, this is interesting and unique to Illinois. Illinois, just so you know, we've gone farther than any other state on this topic. And if somebody is laid off or furloughed due to COVID reasons, then we can't enforce these types of restrictive covenants against them. I don't think it happens a lot, but I wanted you to know about that. So you have something to talk about over a cup of coffee with your friends who work in private sector. But it does apply to public sector as well. And it specifically references the Illinois Public Labor Relations Act, which means, of course, public employers as well. My next slide, just something to throw out there so you know, somebody who, and I guess this goes hand in hand with VESA and the expansion to violent crimes, somebody who decides they're going to leave because they feel that maybe they're in jeopardy or their safety is in jeopardy from continuing to work, they have a right to quit and collect unemployment in the state of Illinois. I mention that to you because oftentimes employees work because they need the money or they're afraid, and this might be a benefit that you could explain to them, and it is kind of a mutually beneficial situation. So on a part-time basis, they may feel more comfortable, whether it's moving out of state or staying away from the workplace, if they feel that there's any safety risks. Obviously, somebody taking VESA leave, we wouldn't hold that against them because they're taking it. One other point I didn't mention when we covered this victim of crime, VESA expansion, and I'm focusing so much on it because the Illinois legislature has as well in the past year in particular. So this is something that will be more likely looked at, particularly in the coming years. The information about VESA time off and the crime and the individuals involved, that does now have to be maintained in a confidential file. And the only time you could disclose it to other people, employees, coworkers, supervisors, would be if the employee consented in writing. So it might be that Susie is a victim of violence, and I want to tell her coworkers that if you see her former spouse on property, alert 911 or call somebody for help. I would only be able to disclose that about Susie now if Susie consents in writing. The Wage Payment and Collection Act is a scary, scary thing if you're an employment and labor lawyer these days. Governor Pritzker did sign an amendment, and again, this is an expansion of an existing law with the Illinois Wage Payment and Collection Act, which governs payment of wages, expense reimbursement, vacation pay, bonuses, if there are any, things like that. If an employee is not timely paid the amount when it's due, and in Illinois, we owe final check either at the time of their last day of work, if possible, rather practical, or no later than the next regular pay period thereafter. Hourly employees have to be paid at least twice a month. Salary employees have to be paid at least once a month. So if you are, questioning when, if somebody has any pay due for vacation, or if there's a dispute about some payment that might be owed, or maybe they owe you on a loan for a repayment of overuse of vacation or sick time or uniform allowance, let's work those things out right away, because if you're found to have delayed in the penalty or delayed in issuance of the final check, there is a penalty of 5% per month of the delay. These claims sometimes take a year or more to get through the Department of Labor. So you are literally talking about 5% per month, 72% interest per year. Also, this is expanded. Employees have 10 years to file these claims under the Wage Payment Act. And also, if an employee files a claim, the employee would be entitled to recover their attorney's fees involved in recovering that matter. This extends to reimbursement for expenses and for bonuses and anything that's covered under the Wage Payment Act. I do get a lot of calls. This changed in 2020. I get a lot of calls on necessary and reasonable business expenses. Employers are required to reimburse employees, including public employers. We're required to reimburse employees for necessary and reasonable business expenses and for losses that an employee incurs if they're using their own tools, or if they're using their own, let's say their cell phone or their tablet or their computer devices. They are entitled to reimbursement. What you want to do is you want to have a policy that carefully explains what your practice is in terms of reimbursement. What is reasonable? Is it $5 a day for meals? Is it, we expect you to go no more than $10 a day for meals? What is your policy? Spell that out. You'll see here, there's a reference on the PowerPoint to, you have 30 days to submit a request for reimbursement. So some of my clients want to say, I want receipts within 7 days. That would be a violation of this portion of the Wage Payment Act as amended. We have to give at least 30 days. If you don't give anything in the policy that says 30 days, there's room for an employee to submit this a year later or 5 years later on an expense that they incurred 5 years ago. So I like to make sure that your policy says we want it within 30 days. You might even say we'll allow a 30-day extension for extraordinary circumstances, but spell out what your goal is in your policy. Another thing employers aren't always familiar with is I've seen employers have policies that say you must include the original receipts when you're submitting a request for reimbursement. Under this amendment, original receipts can't be required. It could be a photo of a receipt. It could be if somebody lost the receipt. I think nowadays you can take a photo of a receipt so people don't use the complaint that they've lost it as much. But if they can't find the receipt, they can't find it on their bill, they can send you a statement in which they say, I attest that I did incur this $5 at Taco Bell on Tuesday when I went to the police training seminar. And then lastly, on losses, it does not include normal wear and tear. It does not include losses due to theft through no fault of the employer or through employee negligence. I mentioned this on here because it is something you'll want to give some thought to for those of you who require employees to use their personal device, whether it's a phone or a computer, for business use, either on or off duty. If you require it, we do have to provide the employees a reasonable amount of reimbursement. Again, your policy will govern that. The only thing that the law says is it can't be de minimis. And de minimis to me means a couple dollars. So if I'm requiring you to have your cell phone 24/7, and I'm asking you to use it at all times for work reasons too, then I should be reimbursing you for a reasonable cost of your business use of your personal phone. In my experience, I think you can come up with a number, even if it's $10 a month, $15 a month, that would far exceed any de minimis amount. This is an issue that I'm seeing unions bargain for more frequently now. I think unions are just learning about this and they're asking for it now to be added, particularly for those who are required to use their own devices or computer on a training seminar or things like that. Again, spell out what your intention is on your policy. I see a question and it says, what if we need folks to have their personal cell phone available only for dual authentication purposes to log into a computer? And that's interesting. I think there's room. Hi there, that's a client. There is room for someone to say, if it's required and I'm required to hold it, then that is something that is a necessary business expense. If it's for authentication purposes, what this person just asked, it might be that it's only signing in and out and it's a matter of de minimis time. And so I would say that you have an argument that that's de minimis. It only takes a matter of less than a minute and that you don't have to reimburse for that. Likewise, it's likely to be a de minimis amount of time means you probably don't have to reimburse for the time spent signing on, et cetera. Where I'm raising the issue more recently is somebody who is required on a weekly basis to submit to testing for COVID, and they're required to submit that and download it. They might do that on their own time, and it could take them an hour that they're standing in line and they're downloading it. There's room for somebody to say that that's compensable time under the Illinois laws. I see another question here regarding comp time for use of a personal phone while an employee works remotely 2 to 3 days a week. What is a reasonable amount? When it comes to comp time, comp time has to be paid in time and a half intervals. So you look at what the actual amount of time spent was. So I would say if your goal is that you want employees to look at their cell phone 3 times a day on the weekends, and it should take no more than 5 minutes each, you would say they're incurring 15 minutes of compensable time each day on their off day. So that's 15 minutes of compensable time. And I would pay that out at time and a half if it's overtime, or comp time at the time and a half rate for the hours actually worked. So in my view, I think the question was worded interestingly, that there does not have to be a 3 or 4 hour automatic lump sum of comp time. You could do it that way, but I think what's equally important is that you do keep track of the amount of time that's spent engaged in reviewing of phones or reviewing of, text messages and things like that, because that is compensable time. Okay. Minimum wage, we know, has been increased to $12 an hour. I assume everybody's at or over $12 an hour already. But when I found some of my employers, at the entry level, they might be raising people to get to the $12 an hour rate because of minimum wage. And they're really coming up against a problem with compression, because I might have been here for a year and I'm only making 12 and a quarter. Keep in mind the impact that raising to minimum wage will have on your other workforce. I don't need to tell everyone it's hard to get and keep good people nowadays. So if you have your employees at the lower rate, and I would suggest to you, look at people, 13 and below and see if you've got those compression issues. It certainly affects your reputation in the world as far as who's going to work for you and employees who might be willing to go to other towns. I don't need to tell you about the difficult times attracting and keeping good people. The Personnel Records Review Act has been amended. This is effective Jan 1. There is a requirement that you notify employees before you release any disciplinary action, even if it's a warning. If it's something in their file and I'm going to release it to another employer or a third party who might be requesting it, even, I don't know what it might be, for a lawsuit or something like that, I am required to notify that employee, not only an existing employee, but an employee who has worked for you in the past year, that is still considered an employee. So existing employees and former employees in the past year, I'm required to give them notice by US mail. Email, text is not sufficient. Notice by US mail, and I have to put that letter, that notice in the mailbox before I respond to the request for getting access to the information. Somebody can raise this kind of a complaint 3 years later. And I do think that this is something that we're going to be seeing more of, that, you might think, okay, well, the person, I'm obligated to disclose that. They only asked for one piece of information. This would be, even if it's one union. So let's say MAP is asking for information about the fire union. That is a disclosure to somebody other than that employee's own representative. So you would have to disclose the fact to the employee that you are releasing the information about their discipline to another person. Somebody asked the question, I'm going to back up a slide. It says, if we pay a stipend for standby time, does it need to be at or above the minimum wage? And the answer is yes. Your stipend must be at or above the minimum wage in terms of the amount of time spent. So if it's a stipend equal to 1 hour and you're on call for 1 hour, and keep in mind, you have a legal right to pay standby time different than their regular pay. So it might be that I'm in a water operator job and I want to have somebody on standby 24 hours, and I'm going to give them pay for all those hours. I can pay them at the $12 an hour standby rate. Okay. Or I can give them a stipend that is equal to X 1 hour of standby pay for the inconvenience, on the assumption that maybe they're never called while on standby. So I would give them the stipend that can be less than the minimum wage, but I still need to compensate them at least minimum wage for all the time spent in performing the services while on standby. So that sounds like it's a discussion in itself, these wage hour issues. And Jen, maybe we want to give some thought to that in a separate interview. I have another one that just came up on the Personnel Record Review Act. Is the notice still required if you have, maybe it's a prospective employer who said that the employee can sign a disclosure notice? And the answer is no, but let's make sure that what the disclosure notice says is enough. So for example, if a former employee or an existing employee applies for employment with another town, and that employer has the application process that says, I authorize you to release this, or I authorize you to get information from my former employer. Let's make sure that that is enough so that it also includes language that releases you from disclosing it. Because it might be the employee signed something with the prospective employer, but it doesn't mean that you are getting a full waiver of the act. I would do it to be safe. You might waste a stamp, but I would do it to be safe, especially if I've got somebody who, is either currently employed or employed in the last year. I might, if I suspect litigation or some follow-up with that employee, why not send it out and be safe? I think there's one other question. Would the notice of disclosure be required if the EEOC, for example, is asking for information about the discipline? And the answer is no. So if it's requested for FOIA, if it's requested for an administrative agency, it could be the labor board, or if it's requested by the union about a member, it could be that they're not asking it about me, they're asking it about Heidi, then, and Heidi's in the same union, then I don't need the notice. Again, when in doubt, I would send the notice. It's as easy as, please consider this notice pursuant to the Illinois Personnel Records Review Act that I received a request from X entity for a copy of your discipline file and I released it. And it's just a one-liner. But again, it is US mail on that. Okay, I'm going to skip to the next one here. I think I'm caught up. I don't know if everybody can see my messages or not, but so I'm going to be reading them, but you can tell me if there's others. The Illinois Human Rights Act, we've spent a seminar in itself on this. Be reminded that for a long time, we can only rely on conviction history, not arrest records. This law changed significantly in Illinois. We go further than any other state on this. And that is that we, number one, have to notify employees if we are going to do a criminal history check on them. There are certain jobs that it is certainly permissible to do a criminal history check. It might even include an arrest record check, a police position, for example, a position that involves, in schools, we have to ask for that. I'm not saying you can't rely on the record of conviction, but any of those that we are going to do a criminal history check, we have to notify the applicant of that fact at the time of the application process. So you might want to put that in an application form or online if you're doing it, and or at the time you receive the application before you do the background check. The conviction record means misdemeanor, felony, or other crimes. It could be even a petty theft. It doesn't only have to be convictions. I need you to know that there's a two process here. I have to notify you I am going to look at your criminal history. I also have to engage in an interactive discussion with you before I make a decision if I'm going to disqualify you. So even if it's an automatic disqualification situation where a police officer cannot have a conviction for this offense, I still have to give you notice, the first notice, that I am going to do the history background. And I also have to give you notice that you are disqualified for that reason. It's a specific notice. I can give you a sample, but it does mean that whenever you're going to use conviction histories, that you are doing more. You have to send a physical piece of paper, when you're making a decision. And you also have to notify the employee at the time of the application process if it's potentially you're going to look at a criminal conviction history. And then also the interactive discussion. The interactive discussion is very important. When you do your interactive discussion, this is what it means. I get the record of conviction on Susie. I look at the nature of her job. Is she working with money? Is she working in a job where she's going to be going into people's homes or, having access to vehicles or equipment that's expensive? If so, then I have to look at, is that a job related situation? And some convictions are. The only thing that would be a violation would be to say nobody can work here if they have a conviction for theft. Nobody can work here if they have a conviction for any battery or assault offense. Any across the board prohibition is going to be your problem. Your interactive discussion, you have to look at the time since the conviction, the number of convictions. Did it happen when the kid was, when the applicant was in 6th grade and it was a petty theft with some buddies down the street at the 7-Eleven? Or was it a year ago? When did they serve their sentence? Other facts involved, the age of the person. Did they, is it the first offense or the second offense? Certainly if it's an offense for DUI, that's going to be job related if they're in a position where they're driving. If it's an offense with DUI that happened 10 years ago, I'm going to question whether you're going to meet the definition that you can rely on that as the basis for denial of an application. Here are the reasons you can use a conviction record, either for the application process or during the employment process. If there's a substantial relationship between the conviction, the criminal offense, and the job, using the other factors that I told you. The nature of the offense, the nature of the duties. Is the person working without supervision? How long ago did it happen? Is it their first offense? Or second, is there an unreasonable risk? Does that employee, if I keep them here, if they're existing employee, or if I hire them, does that employment constitute an unreasonable risk to the property or safety or welfare of the employer, the municipality, or of our employees? That would typically be a situation if it was a violation, a theft offense, or if it was a violation of something that, domestic battery could very well be something that you look at as an unreasonable risk to safety if it happened recently. I'm not minimizing that by any means. It could be a long time ago, but due to the nature of the offense, it's something that would be grounds because you would view it as an unreasonable risk to the safety of others. If it's one time somebody punched a fraternity brother in a bar in college and it was a long time ago and there was a penalty of, slap on the wrist, probably not going to be an unreasonable risk to employ that person. The Department of Human rights is not going to analyze or debate you about whether your decision is reasonable. They're not going to sit in your chair and make those decisions, but they will want to see proof that you did the individual assessment, that you met with the employee and talked it through. When did this happen? Tell me the circumstances. When did you serve your sentence? Give me proof that you've served your sentence. All that information you can ask. I do have a form if anybody wants it, and I can share it with Irma and Jen as well if you want to put it on the website. It's a one-page form that says, here's the job. Does the nature of the job have contact with the public? Yes or no? Do I deal with children? Do I go into people's homes? Is the nature of the offense theft or violence? And it's an easy check the box. It might make it easier for you to do your individual analysis process on that. Okay. I had a question, but it looks like that was answered now. Okay. I'm talking fast and I apologize, but I want to make sure we get through everything. Okay. You must give the employee, so you give them notice that there was a disqualifying offense, you give them the written notice and you give them 5 days to respond. They have an opportunity to respond within 5 days. They might tell you there was a mistake, that it's not them, that they changed their name, that it's their twin brother, that they were set up, whatever else it is. Here's another new law that's likely coming around the bend. Yesterday, the state Senate passed a bill that a lot of other states have already passed. It's called a Crown Amendment. It would be an amendment to the Human Rights Act that would make, it's the Crown, the acronym for create a respectful workplace for natural hair. The logic is that now the definition of race would include traits that are associated with race, such as braids, twists, and the like. That would be somebody that is a factor associated with race. So if you wanted an across the board policy, we don't allow police officers to wear braids, or we don't allow them to have dreadlocks, that would be the same as saying we don't, we make employment decisions based on race. Now, there are certain reasons, for example, a firefighter, there might be a certain length of hair that has to be maintained in order to make sure that the masks fit, and for other safety reasons. There might be a need for police officer to pull the dreads into a ponytail so that they're not on the face, because if they're on a scene, somebody can pull the ponytail and things like that. So you certainly can maintain a policy that the hair has to be pulled back and or put in a bun or tied back in some way. We just can't make a decision by, I'm not going to hire you because of your dreads or because of your twists or whatever else it is. I do expect that to be passed in the near future. I put this on here, the
Thank
Illinois
you.
Healthcare Right of Conscience Act. Oh, was there another question?
Yeah, we have a couple questions coming in. One asks, what about tattoos or facial hair? Was that mentioned as a part of the Crown Act?
In the Senate, it's just a one-liner that says that the Human Rights Act is amended to make this evidence of race. I don't know of facial hair that would be race-based, but where I see facial hair come up is in the context of religion. And if somebody says, I have a religious reason I have to wear a beard and I am not able to shave my beard, again, if you're a firefighter and you have to wear a mask close to your face, I know a lot of those, the warranties, et cetera, will require you to only have a clean shaven face. So if there's no way to reasonably accommodate somebody and have them still be able to wear those face masks. So you might be able to deny someone a request to wear facial hair. Tattoos, again, I don't know that there would be any race-based tattoos. This was intended to cover race in particular and hair in particular. They call it the Crown Act intentionally at the federal level. It does intentionally crown at the federal level. They say that employees view their hair as their crown. It is very demonstrative, and it is something that people, it's important to them. So you can't discriminate against them based on their skin color. So why would you discriminate against them or make employment decisions based on the way they wear their hair if it's associated with race?
And we have
Is that all the questions on that?
But there's other questions on that. We have two other questions that came up.
Sure.
One says, just want to clarify, didn't the hours change for FML from 1250 to 1,000 hours for public universities?
No, there is a pending bill. I know I saw it on the list, and I'm saying yesterday because yesterday is when they just published their new list. And it is a proposal to require all public employers to offer FMLA. I'm predicting that it will not pass, at least as written, because it applies even if you have one employee. And I don't think that small municipalities are going to be expected to give 12 weeks off of FMLA. So I don't know if that's where this was seen. Somebody just did say, and Jen, maybe I misunderstood. I might have been talking over you. I apologize. I think the question was specific to universities. I've not seen that. I'm glad to look it up. There might be something for universities. I'd be surprised. I would think that certainly the FMLA is 1,250, but there might be something unique to universities with 1,000, but I have not seen that. And we do represent a number of universities. So I think I would have seen it. I'm glad to look that up afterwards. If somebody wants to just give me a feedback, I'm not going to charge you or anything. Obviously, I'll just look that up for you quickly. Okay.
All right. And then we had one question that went back to the disciplinary records.
Sure.
What is the timing of the release of disciplinary records? Is it the day the notice is mailed to the employee?
So you have to mail the notice before you release the discipline. So if I mail it, I went down to my mailroom and I mailed it. Now I can email it to the person who asked for it. So it's a date of mailing by US mail, which is not very practical, but that's what the law is.
And one more question just popped up. In regard to the crown, what about its inference in wearing a protective ballistic helmet?
Oh, absolutely. There are safety reasons that those are legitimate business reasons unrelated to race. And you would do that if somebody was, regardless of race, you would require them to pull back their hair or cut their hair so that they can wear a helmet, a uniform, anything for safety reasons. The point is, I can't automatically refuse to hire you. Where I see that more common is hospitality, where they say, I don't want you to wear dreads or colored hair or twisted braids because it's a bad representative to the public. That's where I see that coming up, and I expect that to be something that's adopted by the House and signed soon. Okay, I'm going to just touch on the Illinois Healthcare Right of Conscience Act because this is something that a lot of people asked about when we were first talking about COVID. This law has been around for a while, 2017, I believe, and it was first passed in Illinois so that healthcare providers wouldn't be discriminated against or disciplined or terminated for refusing to issue, like if I'm a pharmacist, I couldn't be fired for refusing to issue a morning after pill or birth control, or a healthcare provider who refused to perform certain types of procedures for women who are pregnant. This law was taken by, frankly, a lot of unions and a lot of employees who wanted to use this as a third reason to ask for an exemption to a vaccination policy. And they say, this is a moral reason, is that I have a moral reason to object to being vaccinated. And this goes broader than vaccination. This goes to even testing. So I have a moral reason to object to, even if you ask me to do a weekly testing for COVID purposes. The Illinois legislature was presented with a proposal to amend this law. And you can see the language here that specifically says it is not a violation of the law, not a violation of this act for an employer to say, for COVID reasons, you must be vaccinated, or you must submit to testing, or you must submit to these testing safety protocol. The point is that employees can no longer hide behind this as an excuse for why they are not able to get vaccinated or comply with an employer's vaccination policy. I do need you to know this, even though it was passed, and it says this amendment is a declaration of existing law and it's not a new enactment. This is the way that the legislature feels the act should have always been construed. It is not effective until June 1 of this year. And the reason is because it was passed in the veto session and it did not have 3/5 majority. And when a new law is passed in veto session without 3/5 majority, the earliest it can be effective is June 1 of the following year after the veto session. So right now there's room for unions and employees to say that they should be exempted for this reason. My own experience dealing with this, and in my office, again, 45 of us, we get a lot of these similar requests. Unions and employees have dropped this in most cases. Some will push it a little bit, but they know around the corner that they can't hide behind this. I see there's another question that came in. Regarding salary history ban, can we advertise and ask for salary history information when we advertise? In the interview, can we ask for prior salary information? The answer on that is no, we can't ask for salary history. We can say, what do you expect to be paid? We can say, how much do you want to be paid if this is your job? How much do you feel is reasonable in terms of vacation time off? We charge our employees 25% for the cost of their dependent healthcare coverage. Is that something that you would find acceptable? You can do that. We simply can't ask for salary history of the employee in the application process. Again, that's not a new law, but I'm seeing a lot of people still confused about that. So I'm glad we're covering it because it sounds like there's a couple questions. Trends in labor law. I wanted to just take the last couple of minutes here. Certainly, we're still seeing effects bargaining with respect to COVID vaccine policies. I'm proud of a number of my clients who have adopted mandatory vaccine policies village-wide, and they are requiring every employee village-wide to be fully vaccinated, even if they, unless they have a religious or a medical exemption, which of course they're honoring. I say I'm proud of it because I'm a freak about it and I have 80-year-old parents, so maybe I'm a little bit biased. I apologize. I know not everybody agrees with that philosophy. One thing I do see as a trend is employers are offering incentives to employees who are vaccinated. They're still offering, whether it's a free day off, whether it's a gift card or a jewel card or whatever it is for those who are fully vaccinated. Somebody asked me today, a public employer asked me, once we lift the mask mandate, February 28th, hopefully knock, can we continue to have the mask mandate in place? And the answer is yes, you can, even though the governor lifts that requirement of, the mandatory indoor masks. Your municipality or county can go further and say, we're not going to lift it yet. My own office, we're not going to lift it overnight. We're saying we're going to phase it in. You might find people really want to lift the mask right away because it affects your ability to communicate and it really affects morale. You got to decide philosophically what's best for you. A common request these days have been that people are asking for Juneteenth to be off as a federal and state holiday. It is now a federal holiday. Last year, it was also made a state holiday. This year, Juneteenth falls on a Sunday. Last year, it fell on a Saturday. So it would only affect those 24-hour employees. It is something employees are now asking for at bargaining. I personally have not seen any municipalities that are adopting it yet. I expect to see some adopting it or trading it for a floating holiday if unions and employees feel strongly about it. Just because the state gives it as a state holiday doesn't mean that a municipality is required to pay for that time. I do have some employers who are saying, I will add that to the list where I pay time and a half or even double time if it falls on a Sunday, if you're working on Juneteenth, whereas I would only normally give you time and a half. All of those things are lawful, but not required. Right now in Illinois and under federal law, unless you are working for the state of Illinois or the federal government, you're not required to pay for that. And so you can bargain that into your union contracts. You're not required to do so. Light duty policies, I'm seeing a ton of work on, a ton of bargaining subjects come up. Make sure you don't tie your hands on your light duty policies. Make sure that you don't tie your hands in terms of the length of time that somebody can have a leave of absence. The EEOC has said for many years now, and it's a very hot topic from the EEOC's point of view, if you have a leave policy in your handbook or in your union contract that says you can only receive 6 months or 3 months of but medical leave and you will not be able to take more than that, or after FMLA, you can only take one additional month, that would be a per se violation. I have seen employers get hit with a per se violation, even if in practice, they have a policy that they let people take 6 months or there's no cap or 1 year, and they never enforce that 6-month cap. The mere fact you have it in your handbook or your policy or your contract is a per se violation, and there is room for the EEOC to say that's a per se violation of ADA. So watch your caps. Drug testing, cannabis. I'm still surprised at the number of firefighter unions in particular that are looking for the right to consume cannabis while off duty. Not that many. It was hot for a while when it first came out, but I think they've dropped it. My police union units are typically saying, we understand it's still a violation of federal law. We're enforcing the laws. We understand that I won't be able to use it while off duty. I'm coming up on my time here. I wanted to just mention this because it was something that I came across in bargaining this week, where I was bargaining with a police union, and they said, oh, these 3 municipalities are offering $10,000 signing bonus for lateral hires. And of course, I followed up on what they said because I didn't believe that somebody would be offering $10,000 lateral hires. Much to my surprise, I found some communities are indeed offering signing bonuses to get lateral hires or new hires for police and firefighter positions. That doesn't mean it's right for you. It is out there, but don't let the unions bully you into saying everyone's doing it. It is a small majority of people who are doing it. And certainly you can ask around on who they are. But I was in bargaining this week where it came up that these 3 are doing it. And it turns out 2 of them were my clients, so I was able to quickly look. Somebody just gave a pop-up here, which is wonderful. Thanks, Tony. Aurora is giving 20,000. That shocks me, but that's, there's a need and obviously a large force, so they need to do that. And I'm up against my time here. I will ask Jen to post this or make it available to you, this website, PowerPoint. It has been taped. If you want to review it while you're driving down the street, or if you want to share it with other colleagues, please feel free to do so. My contact information is at the start, and you are free to call me and ask me any questions. I'm glad to answer them for you off the clock. Thanks for participating. I'm going to stick around if anybody wants me to answer questions now. Have a good day. Be safe, and especially safe driving out there.
So thank you everyone for joining us. If you have any additional questions, you can pop them in the Q&A or chat, and we'll stay on for a few extra minutes to go through them. I did see one question here, and I think you might have covered it. Are you seeing an issue with signing bonuses and unions? So I feel like we just talked about that one, but if there's anything else you want to add on that.
Seeing a union asking, to bargain that, I would say that that's none of the union's beeswax, because that has to do with the initial hiring of an employee. That's pre-hire. But of course, the rate of pay that somebody gets when they're first hired is the union's business. And so, yes, they do typically ask about that, because somebody is going to say, that's not fair to me. I've been here for 6 months or a year, and you're paying somebody else $20,000 who just came over as a lateral. What I'm seeing more is that I'm seeing unions say, we get it, you have to have laterals. Laterals make the world go round now in police employment, but I'm not going to let you hire them at a rate higher than maybe it's your 2nd step or your 3rd step or your 5th step, depending on how many steps you have, so that they make sure that there's not compression where laterals come in higher than existing employees. That is all a subject of bargaining, that the unions do have a right, because that affects the wages of their existing members and not just applicants.
Okay, we have another question that came in. For Personal Review Act, in the letter notification, do you need to disclose the requester, like the law firm?
No. And I'm glad somebody raised that, because as it was coming out of my mouth, I was saying, so-and-so asked for this, and I was more deliberate than I needed to be. It could be that we did receive a request for a copy of your discipline file, and it is going to be released.
Okay, and another question came in. Are you seeing police unions having an issue with implementing body cams before they're legally required by the state?
I I'm seeing a lot of people excited about it, and a lot of people who can afford it are doing it sooner. I have negotiated with MAP. I'm trying to think if I've used it with FOP before, but I have samples I'm glad to share where employers are starting to roll it out even as practice. And I have effects bargaining proposals with MAP that set forth the terms. Candidly, MAP likes to, and FOP like to say they're cutting edge and they're protecting their members, but frankly, the language in these MOUs mirrors the language in the statute. So there are, in my view, the statute already spells out, you have to keep the tapes 90 days. You can only use it here. You have to turn it off when you're here. You have, so in my view, most of those things are already covered by statute, but it is something that the union has a right to ask about. So yes, I am seeing it. And people are excited about it. I think more than not, I'm seeing departments really excited about the chance to have these body cameras. And now, communities are investing in it because they will have to soon.
Okay, another question just popped up. Are matters of behavior or mental health considered the same as physical health issues when it comes to needing time off for a therapy appointment?
Okay, so let's talk this through. So somebody has a mental health condition and they need to take time off work. Time off in terms of the pay is treated the same whether it's a mental condition or a physical condition. Okay, if it rises to the level of a disability, then we also have to go beyond what our pay policies are, our sick pay policies, and grant a reasonable accommodation. So now I threw out all the boring legal words, and I'm going to tell you what that means. So if an employee is taking time off because they were in a ski accident and they need to go to physical therapy, that time might be covered under FMLA. They also would be entitled to take that under the Sick Pay Act if you have, sick pay that you give to your employees. And that would be for a physical reason. If the condition rises to the level of a disability that, it might be a mental condition that rises to the level of a disability, then they would be entitled to even more than FMLA and your sick leave. They would also be entitled to a reasonable accommodation, which might mean either, and again, it's case by case when you're talking reasonable accommodation, that might mean a fluctuating work schedule while the disability exists or while the physical therapy exists. It might mean being allowed to take a longer lunch, et cetera. Case by case for reasonable accommodations. But the answer in a vacuum is yes, mental conditions are treated the same as physical. Keep in mind though, if I'm saying I'm taking off for therapy, that does not mean I'm disabled. It does not mean you need to give me more than what you would normally give for regular illness of COVID or a common cold. The only way you would have to give me more is if it rises to the level of a documented disability. I do have a right to ask the employee to have a doctor confirm it's a disability, and I can send the employee to a second opinion. If it is something that this is an employee in the union, I'll make sure that my union contract terms are followed in terms of, if I'm asking for a second opinion, these are the things I have to follow the union contract for a second opinion. Who pays for it? If the two doctors disagree, is there a right to a third opinion? But not all stress-related symptoms are disabilities. I have seen a huge surge, and I'm sure you have too, of people asking for time off for mental health days, COVID stress days, stress because kids are home with school and just being burned out. That does not necessarily mean that person's disabled. It also doesn't mean the person has a serious health condition under FMLA. So if somebody said, I need a personal health day, this is a mental disability day, I would give the FMLA paperwork and make sure that the day does count as a serious health condition. If the person's hospitalized one day, that could be a serious health condition under FMLA. But if it's a condition that's stress, it would typically have to be more than 3 days off work or somebody who's under a pattern of care, medication, time off more than twice a year. And we know the regular definition of FMLA would govern. Somebody just asked if this is available also on the recording and the PowerPoint. Absolutely. Jen just posted that it'll be on the website as will the recording. I can email it to anybody. I would welcome the chance to talk to anybody. I'd love to meet some new people. or my existing clients, of course, I'll just email it to you. Click of the button. So please feel free to ask.
So Jill, I know we're over on time, but if you still have a couple of minutes, we
Sure.
have a couple more questions come in, and then we're going to have to wrap this up, folks. So the one is a two-parter. How should long-term COVID-related medical problems be covered for employees? And is their job guaranteed upon their recovery?
Yeah, so right now, COVID alone is not a disability. In some cases, COVID's not a serious health condition under FMLA. I do give FMLA paperwork every time that somebody is either, quarantining to comply with the CDC requirements, or if they disclose themselves that they have symptoms or have been exposed to somebody with symptoms, because it may turn into FMLA. And of course, there's strict deadlines on that. The question was how long you have to consider it to be, covered as an illness. COVID, unless it's a disability, is not any different than the common cold. So whatever you do as far as your normal illness policies, you can continue to treat COVID the same way. Having said that, unions tend to disagree with me, and they tend to say you can't force employees to use their own vacation time or their own sick time if the reason that they're sick is because of COVID, and if they were exposed to COVID at work. There are people filing even claims for PETA and claims, under workers' comp, if they feel and can show that they were exposed in a work situation. Personally, and like any disability situation, there is no right or wrong answer. There is no 5 days, 10 days, etc. I do have some clients that are doing a hybrid situation in terms of how much they personally will grant as far as how much paid time off they will grant. And that is, they might say, if you're fully vaccinated, I will give you, I'm just bargaining one today. If you're fully vaccinated, I will give you 80 hours of paid time off if you are needing to self-quarantine for yourself, to follow CDC guidelines, either because you were exposed to someone or you have symptoms yourself and you have breakthrough COVID. That same benefit does not have to be offered to people who are unvaccinated. You can say, look, if you're unvaccinated, you are taking it, at your own risk, and I am not going to give you this additional paid time off or additional excused time off if you could have been vaccinated. I think we all know plenty of people who have had breakthrough COVID, that even though somebody might be fully vaccinated and fully boosted and still get the symptoms. And that's why I would say definitely the majority of employers that I represent are willing to give at least 40 hours, some 80 hours of paid time off. I heard that the state of Illinois gave much more than that. Boy, the number that speaks to me right now is a lot more, and so I don't want to say it, but that's because they negotiated that with AFSCME, and they agreed that if everybody gets vaccinated or weekly tested, we will give you this extra time off. So the answer to the question is it depends on what's right for you. If it's a disability situation where somebody has a COVID condition and maybe they had long-term COVID symptoms with memory or something, or maybe they had really bad symptoms where they ended up hospitalized or on a ventilator, that's like any other kind of disability. You would give FMLA paperwork. After FMLA is exhausted, you would have an obligation to give them a reasonable extension of their time. What's reasonable is no different than if it was a physical condition like broken leg. I'm sorry, not broken leg, that would be more transitory, but somebody who has cancer, somebody who was in a serious car accident. COVID is not treated better than any other condition. The only exception I will say, and I don't know if anybody on here does work in the city of Chicago. The city of Chicago does have an ordinance that says time off taken for COVID reasons cannot be used against the employee for discipline or discharge purposes. But again, it's what is COVID reasons. My personal view is I would follow the CDC guidelines and not more. And remember, CDC guidelines differ based on whether you're fully vaccinated or not. And so you might want your philosophy to be different based on whether you're fully vaccinated or not.
And so,
Any
Jill,
other questions?
I do just want to reiterate. So you're saying for even those, I think you hit on this, those that have long-term COVID symptoms, they could qualify for disability just the same as someone that had cancer or, like you said, was in a car accident or motor vehicle accident, correct?
Exactly. And the
Mhm.
reason is, Jen, because it's not necessarily going to be the COVID. It's going to be the COVID that turned into a respiratory problem or the COVID that turned into a heart problem. And that's what raises it to the level of a disability. The COVID is no different. The COVID, don't you love it when people say the COVID? COVID is no different than the common cold for purposes of the disability laws and the Human Rights Act. That is not a serious health condition under FMLA unless a doctor says it is and checks the box. It is not a disability necessarily. I had COVID breakthrough, fully vaccinated, fully boosted, fully freaked mask. It lasted 2 days for me. That's entirely different than a lot of the people that were on the presentation today. Everybody's different. Mine certainly did not rise to the level of a disability, as inconvenient as it was. Everybody's different. But when it does rise to a level of a disability, particularly if somebody's in the hospital, even one day, that's FMLA.
Okay, thank you. Final
Sure.
question, and then we'll be mindful of everyone's time here. Are employees who identify as LGBTQ plus protected by state law when it comes to employment? And would any adverse situation be considered sexual harassment?
Yes, that is a protected category under Illinois law. And if somebody felt discriminated against based on their sexual orientation or their gender, that would be sexual harassment for sure. Under Illinois law and Cook County ordinance, and for those of you in Cook County, we protect not only somebody's actual disability, somebody's actual gender, somebody's actual race, somebody's actual sexual preference, but also a perception about it. One thing I did come across recently, though, that I was surprised to see, the Illinois Human Rights Act, it took them a while to add sexual orientation as a protected category, but when they did, they added a statement that said, there's nothing in this act that requires you to give affirmative action rights to somebody based on sexual orientation. So I don't need to say that I'm going to treat you better because of your sexual preference, your gender preference, but I cannot discriminate you. I have to treat you the same and not better necessarily. So I wanted to point that out. But yes, somebody could be harassed based on sexual orientation or perceived sexual orientation. Somebody who maybe were spreading rumors or were speculating about some sexual orientation, and it could be wrong. That is where I've seen sexual orientation harassment, where somebody might have been frankly made fun of on social media or whatever because of speculation that was not true. Or even if it is true, perception is covered.
All right, thank you, Jill. Thanks everyone for hanging in there with us for these extra minutes. Jill's knowledge is great to hear from her. And I just want to plug our relationship with Jill and her firm. I want you guys to know that if you have additional questions and you want to reach out to Jill directly, you can find her information right on our IRMA website under membership discounts. If you go to consultants, Jill and her firm's right there. They provide our members with some expert legal and labor advice, as well as giving you a membership discount. Additionally, we partnered with Jill throughout the years, of course, and most recently, she created a personnel handbook guide and an interview process guide. Those are both available on our website as well under the risk management policy templates under human resources and employment. So I would encourage you to go ahead and look at those as well. There's sample checklists and language that you should be including in those guidebooks that you have at your employer base. So any other questions, feel free to reach out to myself, Jen Swalstead, Director of Risk Management at IRMA, or Jill, and we will get this posted and up on our website for you to review or even send out to your supervisors to review as well. Thank you for your time today, Jill, and everyone else. Have a great day.
You too. Thank you. Bye.